outlets in their website. So I am going to turn this over to the Morris County Surrogate's office. Thank you very much again on behalf of Morris County Library for attending and the Morris County Surrogate and her office for presenting.
Good evening, everyone. I'm Christina Ramirez, Chief of Staff here at the Surrogate's office. I will be moderating for Surrogate Darling, and she looks forward to answering your questions after her presentation when she will be joined by Deputy Surrogate Christopher Longo. Now, let me introduce to you Morris County Surrogate Heather Darling. She is an accomplished attorney. She received her bachelor's degree from NYU in Finance and International Business and earned her law degree Juris Doctor from the Seton Hall School of Law. The surrogate is a former freeholder and served as deputy of the board. She was first elected in 2019 as the first woman surrogate in Morris County and took office in January of 2020. Surrogate was overwhelmingly re-elected to her second term in 2024. As a reminder, please use the chat box to send in your questions, and you can do so during the session. And once the presentation is complete, we will read the questions. I will read the questions to the surrogate and the deputy. Okay, Surrogate Darling, you're on.
All right, welcome everyone. I think people are going to be trickling in later, but I'm happy to see everyone that's here already. I'm going to start with a brief overview of the office, and then we're going to move into Q&A after the presentation portion of the program. So, overview of the office: we handle guardianship, probate, and administration. What does probate mean? Probate means when someone passes away, the estate needs to be probated. That is a process whereby the will is proved in our office. If there is no will, there's a process called an administration. Once either of those processes are done, either the executor can be appointed and can then manage the affairs of the estate, or the administrator can be appointed and do so. However, people believe that there's a will that appoints them, they can go and act. Until you have what's called letters testamentary or letters of administration from our office, you're not able to handle affairs such as banking, motor vehicle issues, tax filings, and other things that typically would need to be done. So that is why you probate an estate. That's what brings you into our office most of the time. Probates, we handle between probates and administration approximately 3,600 on an annual basis. And then we have guardianships, which guardianships can either be for an incapacitated adult or a child who has a disability, is incapacitated, and is turning 18. So you can also get a guardianship over a young person, and it's recommended that parents do so if you have a child with special needs that is reaching their 18th birthday. We handle approximately 150 new ones per year, but we monitor those guardianships throughout the life of the ward or until such time as capacity is regained and the guardianship is lifted. So at any given time, we're monitoring anywhere between 3,500 and 5,000 guardianships in our office for an extended period of time. Also, adoptions, we typically don't get a lot of questions on that. We handle about 50 to 60 of those per year. If anybody has questions, we'll be happy to answer them, but usually that's the smallest point of the program. And then records management, as the clerk of the records of the Superior Court, we manage records, we do scanning, we do other things, records retention, and we make sure that that information is protected throughout the lifetime of the individual. And as far as minors go, if a minor or incapacitated inherits funds, those funds are deposited with our office so that we may steward those funds for the individual until either their 18th birthday or, in the case of an incapacitated, when the incapacity is lifted. So that being said, we handle approximately $18 million for citizens of the people of Morris County that we're responsible for going out, seeking the best interest rate, making sure that that money's protected, and the parents or the guardians would make application for the money to receive that. So why do you need a will? Why you need a will is because if you don't have a will, everybody says it goes to the state. The money never goes to the state, but what happens is it goes to the division of unclaimed property. It also causes fighting between family members. And I know people say, well, I'm not around, I don't want to make the choice, I don't want to be the bad guy. That's all well and good, but in reality, you're creating an opportunity for friction. And no one actually needs to see the will as long as they know where to find the will at the time of someone's passing. You don't need to actually share the will with someone, the contents of it, until you've passed away. So realistically, you tell them it's in this place. And when they find that will, then they'll know what it is, but you won't be there if they're disappointed anyway. So you work long and hard for your stuff. And if you don't tell somebody where you want it to go, not only will there be fighting, but sometimes it will go to the wrong place. Some people forget that, oh, I have a distant a cousin or a niece or a nephew or somebody that's going to come looking for money potentially. If you don't have in your will exactly where you want it to go, then that person that you don't even know may end up with belongings that you really had intended to go somewhere else, but because you didn't write down your wishes, and now we're doing an administration and everything's passing according to law, even if you didn't have family that you wish to benefit, maybe you have a specific charity or cause that's near and dear to you, a place that you volunteered or something, and somebody knew your wishes, but it was not written in the form of a will, that distant cousin is going to get your stuff by way of lineage, by way of intestacy. So a lot of people don't really think that through. They think if I tell somebody, then it'll get done. And that's not how it works. There's a process of law it's called laws of intestacy. And what happens under the laws of intestacy is it goes to spouse, then kids, then parents, and out through the branches of the tree. And nowadays, so many people have second marriages, sometimes third marriages. You have children from a first marriage if everything goes to your spouse. The children from the first marriage need to be protected. So there's a lot of different ways. If you have a will, you can take care of all of those things. Also, choosing your executor. Choosing your executor is critical because you want somebody who knows what your wishes are and at least is competent to be able to administer the estate. And by competent, it's not only mental, but it's a capability issue as well. If you have somebody who lives far away and all of your belongings are here, it might be a little bit easier to have someone who lives more locally be able to manage the estate. If we're getting into a time that is more computer oriented, more things can be done online, but still people have to go to offices, people have to collect belongings, people have to inventory homes. They need to set up an auction, an estate auction in some cases. There are a lot of integral parts, moving parts that go into this kind of information. And there's also a lot of missing pieces that people have to collect. One thing that we've done, and I'm going to get into our office again for a second. We've created books. They're on our website, and our website is it's morrissurrogate.com. We have books available there in PDF form. You can also pick them up at our office or local libraries that stock them. I know the county library stocks some. But having your information together, this is a book that we created called The Personal Record of. It's like Mad Libs when you were a kid. It's full of questions and literally like blanks. So who's your accountant? Who's your attorney? Who's your financial advisor? What are your insurance policies? Where are your divorce records? Where are your military service records? Why would you want to put all that in one book? Because if you keep it with your estate planning documents, then that is a roadmap for your executor. Because your executor, unless it's your spouse, and even in some cases, if it is the spouse who handled all the financials and the other spouse doesn't know, that is a roadmap to them to be able to probate your estate. Because otherwise, what a nightmare finding the belongings, right? So they can come in and probate it, but then the administration process of collecting the assets and distributing the assets to the beneficiaries becomes nightmarish because you really don't know what's out there. Also with books, very helpful if you're writing a will, Citizen's Guide to Wills, Trusts, and Estates. It talks about the type of wills. You want to have a self-proving will, because if you don't have a self-proving will, you have to have somebody has to find one of your witnesses and bring them into the surrogate's court. So imagine you wrote a will when you were 25 years old, you passed away when you were 80 years old, and nobody's going to be able to find that lawyer, nobody's going to be able to find a witness. And it's a nightmare now because essentially everything has to go to court, everything has to be proven, and sometimes it's easier to do things at that point by way of administration. Again, not necessarily what the will intended. So you're creating two different options, both of which are really going to be nightmarish in terms of the process that you're going to have to go through, that your family member's going to have to go through. So if you make a self-proving will, you choose your executor, you choose your beneficiary, and you make sure that everything goes the way that you want it to go. It's a much easier process. And again, on the executor, location, 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 still. Also, you want to have somebody, you can pick your spouse, you can pick your sibling, you can pick your best friend, but if they're your same age, now we're playing the odds. So if you're 18 years old and you write a will because you just had 2 kids, maybe you want to start naming kids as executors for the future. Because if you're 18 years old, presumably this will is not going to come into play until you're much older. So you may name your parent, your sibling as the first line, but then future lines would be potentially your children because they're presumably going to be adults. And then beneficiaries. I will say that I mentioned earlier charitable beneficiary, just remember that if you name an amount to go to a charity, they're going to get that amount first, unless you so specify in your will that they get X amount if there's anything left after everyone else gets a minimum of this. But if you start working with them and not qualifying it, what happens is you may only have $10,000 at the time that you passed. You thought you were going to have a lot more. You said $10,000 to my favorite charity, and now your family members who did want to benefit to some degree get nothing because the charity gets it all, and they can actually enforce that. It would become a lien on the estate. So when you pick beneficiaries, if you're picking percentages, typically because you don't know at the time of your death what the amount is going to be, then you want to pick in a way that makes sense. Now, obviously, I recommend that nobody goes out and gets an online legal program to do this. You should be getting experienced legal counsel to handle this documentation for you because it's so critical. And if you live in Morris County, you own a home, you're probably worth at least $1 million. And a lawyer's going to charge you maybe $500, $1,000 to do this document. So if you're spending $500 to $1,000 to protect over $1 million, I think it's money well spent, in my opinion. So something to keep in mind. And one of the programs that we created, the first program that we brought forth was the reduced fee attorney referral service program. So if you're somebody who needs to make a will for whatever reason, maybe you do not have a lot of assets, but you own a home and you don't have a lot of income coming in. If you qualify through the Morris County Bar Attorney Referral Service, they will give you an attorney for a reduced fee of approximately, I believe it's $70 an hour or so right now, as opposed to the numbers that I just said. So it is there, it is a benefit. You apply through the bar and it's in conjunction with our office. We have the applications available here. And then also bouncing back and forth a little bit, we talked about the books. We also have the surrogates annual report. We do this every year. I gave you the numbers of cases that we handle. They're detailed in the book, how much money we generate from operations that we bring into the county to subsidize county operations, and our office is in the book. I also ran on transparency, and this is transparency. It talks about changes in staff. It talks about technology updates. Everything that we do in this office on an annual basis is included in that book so that the citizens can see it. It's available in print and it's also available on PDF in our website. So you can find that. Again, that's morrissurrogate.com. And while I'm talking about the website, I want to tell you guys, we have some new technology updates. We have an AI chatbot on our website that's been there for about a year now. It's a great search box. If you put something in, it'll take you to forms, it'll take you to how-tos, it'll take you to really anything you want to see on the website. And it's very beneficial if you're thinking about writing a will, or if you're an executor and you need to figure out how to work with our office. Also, you can schedule your appointment on the website. You can now pay by credit card through the office. There's so much that we've done technologically that people are just not aware of. So think about availing yourself of the option of going to the website. And also, we now have a virtual assistant. We have Hannah. So if you call the office outside of operational hours, or you call the office and the front desk receptionists are busy, as opposed to getting voicemail, you're going to be able to, you're going to be answered by a person. Sounds like a person, it's not, it's a bot, it's a virtual assistant. But she'll say, you've reached the Morris County Surrogates Court. This is Hannah, the virtual assistant. How may I help you? And if you say, my loved one passed away, I need to probate the will, she's advanced enough to say, I'm very sorry for your loss. And she moves on from there, asking you questions like, when did the person pass away? Did you want to make an appointment? Did you have questions? She can make you an appointment to come in. She can answer certain questions. If you already have a probate clerk that you know the name of that person that's been assigned your case, you can tell her that you would like to be transferred to the probate clerk that's been assigned to your case. You can also be transferred to the guardianship cases directly, to the guardianship clerks directly. So you can avoid going through. We don't have the menu options. We don't have anything like that. It's not press 1 for this, press 2 for that. You get Hannah and Hannah will route your call. And at any time during the call, if you say human, speak to a human, voicemail, I want to talk to a person, it's not a secret code. Anything that you say along those lines will take you to a human, because we know that these are highly sensitive matters and people do frequently prefer to speak to a human being. So I know you guys have questions, and in a minute, I'm gonna bring my deputy in and we're gonna do the Q&A. But before I do, there's one other thing that I wanna say. Designated beneficiary policies. People say, how can I avoid probate? So in Morris County, probate takes literally an hour, most cases, in our office to handle the documentation. As long as you have an appointment and you bring the information that we have sent you, telling you that you need to bring this information to our office, specifically the original will. You have to bring the original will, not a copy, in order to probate. And you bring the death certificate and you bring proper identification, identifying yourself, because you're going to be named the executor or the administrator. So if you have what we email you before your appointment, it's pretty smooth sailing. Now, if you still want to avoid probate for one reason or another, how you avoid that is designated beneficiary policies, whether it's insurance, annuity, a bank account, a trust, any of those things passes outside of probate. In the event that the trust is created under the will, that's different. You're going to have to come in for probate to create the trust. So with that, I'm going to have my deputy come over and join me in this chat, and we're going to open it up to questions. Christina will be reading us your questions. Everyone will stay muted and we'll answer them accordingly. And this is Christopher Luongo, the greatest deputy in the surrogates court anywhere in the state of New Jersey. He has been with this office for over 30 years now. And this guy knows everything. I've been here 7 and I feel like I know a lot, but Chris can open the statute book to the exact page and can cite the statute for you before he goes to the page. So you guys get a huge bonus by having him on with us tonight.
Thank you, Heather, and the pressure's on.
Okay, first question. What power of attorney activities are allowed before probate is complete?
So power of attorney extinguishes, it's a lifetime document. Power of attorney extinguishes upon death. So when the person passes away, the power of attorney becomes null and void. Hence, if an individual is incapacitated, you should have a guardianship in place. That would also cease, so the will takes over at that point. In the event that you were taking care of a certain person's affairs under a power of attorney, also extinguishes upon death, so you can take no further action.
Okay. Can you use a template online, and what is the purpose of an attorney? And do wills and trusts need to be notarized?
You can use a template online, but as I said, I strongly recommend that you don't use a template online. It's not a huge difference in cost between that and an attorney who's going to recognize certain things that you say and know to ask other questions. And I'm sorry, what was the second half of that, Christina? Christina.
Let's see. Sorry about that.
Yeah, me too.
Wills and trusts need to be notarized.
Oh, yes, well, the trust, okay, the trust does not pass through our office if the trust is not created under the terms of the will. But yes, those documents will need to be notarized, and as I said, a self-proving will actually is signed by the testator and the two witnesses in the presence of the attorney and or notary. And everyone confirms that they are witnessing each other's signatures, that this all happened at the same time. And there's an attestation clause included that designates it as a self-proving will. And that is what you want to have.
Okay. Someone else is asking if there's a website that they can use to find an attorney in Morris County. And I know you talked a little bit about the Bar Association, so I'll let you answer that.
The Morris County Bar Association has a lawyer's referral service. I don't know that they have a website for that or not. You'd have to check that with them. And certainly you're welcome to use any search that you want on the internet. I'm sure you can find plenty of attorneys, but I think that the lawyer referral service through the bar is going to be more specific.
Okay. How long does it take to resolve a will after death?
To resolve a will, you mean to probate?
I think this gentleman or woman means actually processing what the wishes are of the testator, because it says my mother passed in August of 25. Her house was sold in February of 26. And so I guess she's waiting for resolution.
It can take years to wrap it up. So that part of the process does not happen through our office. Once you have been named as the executor or the administrator, then that happens thereafter. The only reason that it would come back into our office after that is in the event that there needs to be an accounting. In which case, if there are multiple beneficiaries who maybe start asking questions, there's a difference between a formal accounting and informal accounting. Those would go through our office and require various levels of review. And in that case, it's recommended that the person probably would have an attorney and possibly would have an accountant for the accounting.
But the typical estate lasts between 6 months and a year. So if it was probated in August and the house was sold in February, it should resolve within a year.
If you have property in other states, do you need an attorney or a will in each state?
That's a very interesting question. So no, you do not. What you do is you would probate the estate. The estate is probated in the county that is the last residence of the individual at the time that they pass. So for example, if you live in Morris County, you have a car accident in New Hampshire and you pass away in a hospital in New Hampshire, but you were a resident of New Jersey at the time that this took place, your estate would be probated in the Morris County Surrogates Court. Now, your property that you would have in another state, let's say Florida, you would then take proof that you had probated the estate in New Jersey for the benefit of creditors, you would provide that, the executor would provide that to Florida. And Florida would then issue probate with regard to that specific property. Various states have various statutes on that. Here in Morris, the property could be liquidated and dealt with at any given time or transferred at any given time. Other states have an extended waiting period. So if you do find property in another state, you should immediately contact that state and find out what their procedure is. And you may or may not wish to get an attorney based on the procedure and how helpful you find the court to be in the other state.
You talked about a self-proving will. What constitutes that, and is that notarized?
Chris, you want to do that?
Sure, a self-proving will has a clause at the end of the will that basically says that the person who's signing this will is over the age of 18, not under any undue influence, and has testamentary capacity to execute a will. That clause is signed by 2 witnesses and it's notarized. So yes, it has to be notarized. So since 1978, all wills should be self-proving, and most wills coming to our office are self-proving. So if you don't have a self-proving will, you should make one. You can make it after the fact. Let's say you have a will from 1972, you can still get it executed. You just re-execute it with the self-proving affidavit. You can probably find the self-proving affidavit online. So yes, it has to be notarized.
Okay. This next question has a couple of parts to it. So this person has a neighbor who she has the power of attorney for. The neighbor
All right.
is,
Christina.
I'll make it impersonal.
Yes.
If someone has the power of attorney for another, and that person is not available to come to the office because their son passed away or their child passed away, can the person with the power of attorney deal with our office on behalf of a person who lost someone?
That's kind of a stretch, Chris.
No, you can't. In other words, it's the power of attorney to be the executor or the administrator on another estate. No, you can't do that.
It would be an administrator, no will.
No,
No.
you can't be. You have to be in the bloodlines or in the will.
Okay. So the person would have to come to the office, make an appointment, or file electronically for administration, right?
Right. We do have electronic filing. That actually is a great question because it's something that I didn't mention. You can actually file online and mail the originals to our office. So you don't have to come in, but you should look into what's available on the website, and the chatbot on the website would enable that person. It would guide that person through the process largely. So that avoids the trip.
And the signatures, once you receive the documents, would have to be notarized
Yes.
by the person.
Yes.
Okay. All right. If a will has been notarized, is that okay? I mean, that's a theme here. Yes, all wills must be notarized, correct?
That's correct.
Yes. Okay. If a home is left equally to all siblings and some live there rent-free, what needs to be done to sell the house so all siblings receive equal inheritance? Can they be asked to move to enable a sale of a home?
It depends on the terms of the will. They'll inherit equal shares, and if some want to live there and some don't, then they could try to work it out amongst themselves. But in reality, if they can't come up with a reasonable figure based on actual rental values and something that they agree on, then they can sue for partition of the estate and divide the proceeds. And it involves evictions and all kinds of neat little things. So not always the greatest idea.
No, you have no right to be there after the person dies. You have to scram Bottom line is, unless it says something in the will, before death is different. After death, the executor has the absolute right to
So
sell property.
what if you and I and Christina and 3 of our other brothers and sisters inherited it?
Yeah, if you inherit it, but you don't have the right to live there.
Well, if you inherited it and you don't leave,
You're out.
we have to evict
Yeah,
you.
you have to,
Right.
yeah. Well, you'd have to go to court,
Yeah.
correct?
You'd have to get them evicted, right?
Yeah.
That's tough work. Okay, if you have a will done with an attorney, do they provide witnesses if needed?
Some do, some don't. Depends on the size of the firm, and sometimes they might go grab a friend from next door, which is why you want to have a self-proving will, because you're never going to find that witness again.
And the attorneys do self-proving wills, correct?
They should.
They should, yeah, all do self-proving wills.
Okay, so this is a question that comes up all the time. If I have assigned a designated beneficiary in my stock portfolio, bonds, etc., do I still need to include this information in a will
No, anything with a designated beneficiary policy passes, or designated beneficiary passes outside of probate. So payable on death accounts, annuities, insurance policies, trusts, all that is outside of probate.
Jointly held property.
So a home and a car, if they did not have designated, that would be in the will, correct?
Well, if the home is owned jointly with rights to survivorship, and the vehicle, you can now have a designated beneficiary on a vehicle. It's a relatively new statute, about 3 years old, because people were coming to the office to probate just the car, just to be able to sell the car after the person passed away, because they were living on Social Security and that's all they had left. And sometimes the value of the car was less than the price of probate. So that being said, you can put a designated beneficiary on your vehicle as long as you're titling a vehicle. Now, if you own the vehicle, you can't go add it unless you retitle it. But you can retitle it if you want to add it.
Okay, once you disperse all the monies in an estate to all the heirs, what do you do after that with probate?
You want to talk about the refunding bond?
Sure, before you disperse money to the heirs, after all the creditors have been paid, you should give the beneficiary what's called a release and refunding bond form. You could find it online. And basically, this form would say to the beneficiary, hey, you're getting $25,000. Before you get the $25,000, you have to sign the release and refunding bond. The release says you release the executor or the administrator from any liability handling the estate. And you also agree to refund the money in case there's a stray creditor out there that wants money that the executor wasn't aware of. So that's the document that really needs to be executed before you distribute any money. Because without it, the creditor could come forward and sue the executor directly and they'd have no recourse. If you have the release and refunding bond before you give the money out and there's a claim, a stray claim after the fact, let's say 2 years later, it's an absolute shield against the creditor for liability's sake. So that's the most important thing you can get. Now, once you get that, you just submit the forms to us, like $5 a page, you stamp file it, and the estate is done. So it's a fairly simple process. And once you pay everything, once you pay the beneficiaries, get the release and refunding bond, there's no need to account or do anything else. So it can be a very, very simple and straightforward process.
It can be, but in the case that somebody requires a formal accounting because they don't trust the executor's account, usually in the case of siblings or cousins and family members, and also if there's a charitable beneficiary that gets a percentage, they're going to want to see exactly what was there because they want to make sure that the percentage they were given, the amount that they were given, was actual based on the percentage and there wasn't some skimming going on. So in the case of a formal accounting being required, then that would happen. You'd need to provide that to the beneficiaries. They would then review it, and only after they agree with it would they sign those bonds. Of course, they can challenge those bonds, they can challenge that accounting at any given time. Doesn't mean that the judge is not gonna admit the accounting and let it go to probate. And then you're gonna sign that refunding and release bond if you want your money. But if the judge decides to question the accounting, then it could be a long drawn out process.
Can you explain the benefits of a trust, of having a trust?
Briefly, I'll explain it for purposes of this seminar. So a trust, like I said, can avoid probate. It also can protect your assets from creditors. There's different outlooks on this, but they have the 5-year look back on the Medicaid trusts. There's special needs trust. If you have a child that has special needs and you want to make sure that the money is protected so that they continue to get their benefits, including their housing and everything, you would put the money into a trust for that. There's charitable trusts, which if you're watching this program, you probably don't need one, because if you need one, you probably have a very high priced attorney out there working on it for you. But there are people who do charitable trusts as a way to avoid paying taxes in the present. They go by last names like Gates, things like that. They're not usually your run-of-the-mill person that does it, but we are in Morris County. It's a pretty affluent area, so it's not the worst thing to look into if you're meeting with an advanced estate planning attorney, somebody who actually knows the ins and outs of that process.
There's also testamentary trusts. Those are trusts created in a will, which is designed, you can have a trust to protect someone because you feel like they're unable to manage their money. So you have a trustee and a trust and it would disperse that money according to the terms of the trust. So Heather was just talking about inter vivos trust. There's also testamentary trust. So it's a very big topic.
And there's also revocable and irrevocable trust. So irrevocable trust, I'll make it the simplest possible form. Irrevocable trust means you gave your money to someone else to manage forever, and you can never take it back. They're managing it for you and making your decisions. And then there's irrevocable, and irrevocable means you can take it back and it's yours again, but that offers you no protection in reality, because if you can take it back, it means it belongs to you, and that means that the creditors you're trying to avoid or any of the other things you're trying to do can go and attach that money because it's essentially yours.
Okay. Are holographic wills still acceptable?
Evidentiary only, Chris, you want to?
Holographic will is a will written in the handwriting of the decedent. It can be acceptable. It depends if it was executed, if it had 2 witnesses and it was notarized. In the absence of that, you would have to go to court and to prove and make an application to admit the will to probate through Superior Court. But a holographic will is not advised for execution purposes, and it's really important that most 99% of wills are typed up. Doesn't mean a holographic will is not acceptable, but the proof requirements are different, and I would not recommend it.
If a will is created 20 years ago, should a new will be updated with new beneficiaries?
Typically, in the case of afterborn or adopted children, family members, the will is typically drafted in a certain way that it handles by operation of law, bringing in new people, bringing in children, bringing in grandchildren by way of lineage. In the case of a divorce, once the divorce is filed, that person is severed from the will. There are a lot of things that move by operation of law, and you really shouldn't be putting on, my 2025 Corolla or whatever should not be in your will. Your bank account at this bank, that shouldn't be in your will. That kind of stuff, where your accounts are, that should be in the personal record of those numbers, those accounts, the names of the bank. They change all the time. It would just be so so cumbersome to put that in a will, and then you'd have to update it all the time. Strongly not recommended. You want to talk about collecting the assets and dispersing the percentages. Chris, you want to?
No, that's fine. Yeah, I agree.
Are there any circumstances that exist that you can avoid probate?
I think
Yeah, I think Heather handled that before. If all your property is held jointly or it have bank accounts are payable on death, anything where there's a designated beneficiary, you can avoid probate. So, but there's nothing to be afraid of probate. You know, it's just, you know, if you, for some reason, you don't want it, you want everything taken care of beforehand, you know, you can certainly do that. But if, you know, a lot of people don't have been designated beneficiaries in some of their accounts, so, you know, there's nothing to be afraid of, and there's nothing wrong with that.
And by the way, you can put someone else on a deed during the lifetime. You can put them on with rights to survivorship to make sure that that person gets what the house, if that's what you want them to do. So there are ways to go about it. But you know, I'm going to be very clear with you regarding probate. It is in Morris County, not a lengthy process. But if you live in Morris County your whole life and then go to a long-term care facility in another county, the probate process may not be the same. And you may end up with a 9-month minimum in another county as opposed to an hour minimum here. So that is something that you should be cognizant of, and don't take for granted that you're going to get the Morris County 1 hour probate, because as you get older and things change, you don't necessarily know that it's going to go that way.
If there's a will signed by the testator, but it has not been notarized, is this a problem? Is that an acceptable will for probate?
Chris, you want to take that?
If it's signed and there's witnesses, if there's 2 witnesses to the will, we would, and it wasn't notarized, we would require a witness proof, which is a document that one of the witnesses would have to sign, and it has to be notarized that they saw that person execute that will. So you can probate a will that's not self-proving, but it's a different proof requirement. So we would actually ask for, you know, one of the witnesses to come forward and sign a document acknowledging that they signed the will and it was properly executed. So if you can't find the witness, and this happens occasionally where you can't find the witnesses, the will doesn't get admitted to probate. So in that case, it would be intestacy.
And this goes back to what I was answering earlier with regard to the self-proving will, or with regard to the witnesses. Does the attorney provide witnesses? Again, now, you made a will when you were 25 years old. The attorney at the time was 60 years old, and you can't find the attorney. How are you gonna now find the witnesses if you can't find the attorney? And if the witnesses, you were 25 and the witnesses were 50 working in this attorney's office, the odds are they're not around to find. So self-proving will is the way to go, 100%.
But just to reiterate, if a will has been signed only by the testator and there are no witnesses and it is not notarized.
It's going to be evidentiary at best.
Okay. What if an estate does not have enough money to pay all its creditors?
You then they're out of luck.
So there's actually a formal bankruptcy proceeding. It's not called bankruptcy, it's called an insolvency proceeding. Most of the time, if the creditors, let's say there's $30,000 in assets, and let's say $100,000 in creditors, you could call up the creditors and you can negotiate with them and they can accept less than that, or a third on the dollar. If they don't accept that, and you can't get all the creditors to agree, you would actually file an application in Superior Court for a court ordered insolvency, and the court would pro rata didn't make a distribution to all the creditors. But the problem with that is if there's $30,000 in assets and $100,000 in liabilities and creditors, the attorney fee to make this application is going to be around $30,000. So the creditors have an incentive to settle, and a skilled attorney would be able to bring the creditors to, to accept that. But it does happen. But a lot of times, if someone doesn't have any assets, there's really no reason to probate. You don't have to probate anyone's will or do an administration if there's nothing to probate. If it's just bills, you don't have to step into the shoes of someone who has a lot of bills and say, there's nothing to pay them with, there's nothing you can do. So you can always consult an attorney on that.
Can you make suggestions on where someone should keep a will after it's been executed? Is there a registry? Should it be kept to the attorney's office? Should the executor have it? Safe deposit box? All of those things.
So there is a registry. There are, to the best of my knowledge, exactly 0 people on the registry list telling people where their will is located. But it is available. So before Trenton does away with it, maybe somebody on the call should just put their name on the list and reserve it for future generations. But safety deposit box is not currently recommended. We do have a way to get people in. It's a bit of an annoyance. I believe that they might be making an expeditious process that's going through the legislature now to see whether they're willing to allow it in certain circumstances. I'm not sure Chris's status of that.
Yeah, I'm not sure, but it is the chicken and the egg. Where do you put the will when you're dead? The best practice really is to tell the executor or someone you trust that the will is in my kitchen cabinet, wherever it is. You have to explain, tell someone, because if you don't, it could change everything. So, you really have to communicate while you're alive. And like as Heather said, you can put it in a bank safety deposit box. The problem is the bank won't let you go in unless you're an executor. Well, you're not an executor until you get the original will, so it's the chicken and the egg. So,
although apparently some banks will. Somebody called the other day and said we were wrong with that. But the other thing about that is as far as where you're going to keep it and who knows about it, it comes down to the lawyer's office. If you want to keep it with the lawyer's office, that's something that in law school we were taught, don't do it. As the lawyer, don't do it, because it's kind of fishing for future business. But not only that, you go look at the names of the big law firms, they're constantly changing partners. So who's the one that did your will when they left? Did the will go with them? Did it stay with the firm? Is the person still alive? If they passed away? Did they sell their practice? What about their records retention process? It frequently happens that family members, they don't remember the name of the attorney passed away, they can't find them. It's not a great idea to do that. Like Chris said, I mean, whatever spot you pick, just pick a safe spot that nobody's likely to look and tell your executor where to find it.
One other caveat, we do not hold wills as surrogate's office.
If someone dies and they have a mortgage on their home and it's not, obviously it's not completely paid, what happens?
The equity, go ahead, Chris.
It follows the whoever the beneficiary is. It's not exonerated. It's the debt follows the real estate. So the beneficiary has to pay, assumes the debt.
And ultimately, if the beneficiary cannot continue to pay, or if they can't qualify with the mortgage company, because the mortgage company frequently is going to want to put the financing in the name of that individual, if they don't have the credit worthiness to be able to pay after examination, then the house would be sold. And the money that's due to the creditor would go, or to the mortgage company would go to the mortgage company, and the beneficiary would get whatever equity was left. And
Why do so many homeowners put their homes in a trust?
It's,
It's called a Medicaid trust. I mean, not everyone does this, but you can. The theory is if you put it in a Medicaid trust, for nursing home purposes, the nursing home can only look back 5 years. So the trust, if you put it in the name, the house in the name of a trust, the government can't look back and grab those assets to pay for your nursing home. The problem is when you do that, you're put yourself in a position where you don't have enough money to get a nursing home. So your ability to fund a quality nursing home is severely restricted. And a lot of attorneys don't explain that very clearly. They just say to a lot of people that, hey, listen, you're going to save money on taxes. Yeah, you're going to save money on taxes, but you're also not going to have the best nursing home. That's what they should tell you. So that's primarily why people put their money in trust. It's called, Medicaid planning is what they call it.
a lot of people do it though, used to do it based on the tax codes. And now that the estate tax numbers have changed, people in New Jersey, you don't have that incentive that you used to have to put something into like a qualified personal residence trust to get a discount on the transfer where you're using stepped up basis and all these fancy terms that just don't apply at the moment. But that doesn't mean that in the future, when the government decides they need money and they want to put they want to put lower numbers back on these taxes and start taxing you at $1 million instead of $15 million as the minimum to start the tax calculator tolling, then it's worth looking into. So either be aware of the tax codes or talk to your accountant about them on an annual basis and just find out where things are if you have an appreciable amount of money.
So how does one know all the liens or, monies owed of a deceased before they start dispersing funds?
Very good question. They used to have a law, and it's been repealed. It was called the Order to Limit Creditors, and it was in New Jersey you would pay for an advertisement in the newspaper, and the newspaper would say all creditors of John Doe come forward within 9 months. And if they didn't come forward, you could distribute the money. It doesn't mean it absolved the debt. They got rid of that law. Basically, in my opinion, the way you'll find out about creditors just checking the mail after the person dies. There's going to be bills coming in, and you could also ask their accountant or their lawyer. Creditors want to get paid, so you'll know for real estate purposes. You can look that up pretty easily. But all other bills will come in after the fact. So there isn't. That's why you need to have the release and refund bond when you distribute, because you protects you after a certain amount of time. If you do distribute the money to the beneficiaries, if a stray creditor comes forward, you can get the money back from the beneficiaries. So there's really not a great answer for finding out who knows who's I don't know who Heather's creditors are, even if she has any or anyone else. But if you check the mail, you'll find out pretty quickly.
But there are states, remember, you don't necessarily stay in New Jersey for the rest of your life, depending on who's watching this. And that being said, if you move to a different state, while we can probate very quickly, we can give you letters testamentary very quickly. There are certain states that have a restriction on the transfer of assets for an extended period of time, like maybe 6 months or more, to allow creditors to come forward. And if they don't come forward in that amount of time, then there's possible extinguishment of the claim that they would have had. So again, New Jersey law, as Chris explained it, but remember the various states may have various other things. So if you move, look into the laws in the state that you've moved to. If you purchase property in a state that you don't live in, look into those laws as well.
Are there fees to probate?
Yes.
Around $100, $100 for a will, 125 in that range.
You want to talk about it?
It's like $5 a page after the first couple first 2 pages, or
You want to talk about the executor fee while you're at it?
Okay. Yes, there's fees, that to probate, but they're minimal, around $100. And then the executor who does the job also is entitled to what's called commission. You're entitled to income commission, which is 6% of any income that comes in during your administration of the estate. And you're also entitled to corpus commission, which is based upon the percentage of assets you handle. Now, the commission is 2% for the first 200,000, 3.5% from 200,000 to $1 million, and 2% over $1 million. So it can be pretty sizable commission, but you're entitled to it. You should take it if you are the executor. It is taxable to you. You can petition the court if you do more work. You can petition the court for additional commission. So you're entitled to corpus commission and income commission. So that is part of the cost of probate. But if you have a good executor, they're worth their weight in gold, then I wouldn't hesitate to pay it.
Can one use an attorney who practices in another state to draft a will for someone who lives in New Jersey?
I don't recommend it. It's, if they don't know the laws, if they don't understand the nuances that we're talking about, like restrictions on transfer of assets, they're not gonna be able to, there's drafting, and then there's adequately informing you about things you need to know. And those include the probate laws and codes and the way that they're gonna impact your executor and the ability to probate that will. So I strongly recommend picking somebody who not just is an attorney licensed in the state, but an attorney who is familiar with probate in that state. Chris, you want to add that?
No, I think you hit it up right perfectly. I think, there's 85,000 attorneys in New Jersey. You could find one. Again, I think the first question was, go to the Morris County Bar. They can refer you to one, or you can even just Google it. Good names come up. So.
Okay, we're coming up upon the 7:30 hour, so I'm just going to try to get two more questions in. If someone can't find their original will and only have a copy, what do they do?
Good question. You cannot probate a copy of a will. It's presumed if there's a copy that the testator destroyed it. So if you can only have if you found a copy of it, you can still probate it, but you'd have to go to Superior Court. That is, you'd have to file a lawsuit and you'd have to bring in witnesses, you'd get a court hearing, you'd have to bring in witnesses, you'd have to explain that this was the testator's intent, we just can't find the will. He did not destroy it, he had the same relationships with all the beneficiaries.
If the testator is still alive, can they just have it notarized again?
Correct, you can just do a new will, that's the easiest thing to do.
Yeah.
But no, you cannot probate a copy of a will.
Including having it notarized again. You still would have to, it would have to be all what they call a wet ink original.
Okay. There's some confusion about the new registry for the wills, and just clarify that there is no registry.
There is a registry, but no one has ever utilized the registry. It's in Trenton, and no one has ever utilized the registry according to all accounts from Trenton.
I think the registry is like, my will is.
My will is in my kitchen cabinet or whatever, yes, it's loaded.
I think I thought they abolished it.
Every year they have an effort to abolish it by somebody and it fails.
Oh, really? Yeah, okay.
Because no one's using it.
Yeah.
Okay. So we are at the 7:30 hour. I know that you have a closing.
So with that, I want to say thank you to Ann Mazzara and the folks at the Morris County Library for offering this to the people of Morris County. I think it's very beneficial. I hope that everybody learned something tonight. I want to thank my staff who is here from 6:30 to 7:30 tonight doing this for you when I'm sure they'd rather be home with their families and friends. So a special thanks to my deputy, Chris Longo. Like I said, he's the greatest deputy out there. I'm lucky to have him.
Thank you.
He's past retirement time and he doesn't need to be here, but we're clinging to them
I
for
just
dear
don't
life.
want to be past the next time, you know?
And we've got Christina Ramirez, who has been asking us the questions, my chief of staff. And you guys can't see him. I don't know if he could step in front of the camera, but I've got my systems analyst, Chris Paz, here with us tonight as well, making sure that everything goes smoothly for us. So this goes well because of your participation. So I want to thank everybody who signed up tonight, who asked questions, who came in and participated in this. And I know we've got another one coming up in about 6 months live at the library. Usually it's a lunch and learn. So if you didn't get your question answered tonight in the hour that we had, hopefully you can make it to that and get your question answered there.
Thank you.
Thanks, Chris.
Okay. Thank you.
Okay, thank you everyone for attending. I am going to close this Zoom. That will close the Zoom for everyone, presenters and attendees. Thank you.
Thank you, Anne.
You're quite welcome.